Court of Appeals, Division 1 is now in session.
Good morning. You may be seated. We are here on our case number 1CA CR150342, State versus Gutierrez. Counsel, as you know, each side's allowed 20 minutes for your argument. You may reserve any amount of time you'd like to use for the appellant in rebuttal. If you do decide to reserve time, you must keep track of it yourself, because the clock on the podium will reflect the total amount you have remaining, including what you may have decided to reserve. We record these proceedings, so when you approach the podium, we'd appreciate it if you would recite your name and the name of your client for us, and for the appellant both times if you come back. On the bench here, we have a stipulated motion to transmit certain exhibits from the Superior Court that was submitted today.
Yes, Judge, I'd be happy to address that, or I can do it during the argument if you wish.
Let's hear about it now.
Sure. Essentially,
Approach the microphone.
sure.
Yeah.
Essentially, in preparing for argument, I came to the court last week to look at some exhibits and realized that several of the recordings that were admitted at trial were transmitted back to Yavapai Superior Court. And so this is just a stipulated motion to request this court to order them be transmitted back to the court, because we believe they're critical to the resolution of the appeal.
On the severance?
Particularly on the severance issue. And I just wanted to have that filed prior to argument, so that if there are any questions about it, it's our position that the court should review those in resolving the severance issue.
Okay, and Ms. White, you agree to?
I would agree. I believe that they are should be part of the record, and they were simply submitted. Apologize. They were submitted or brought up on appeal on the co-defendant's case, but for whatever reason went back. Yeah,
I got it. Okay.
That's it.
All right. I will grant the motion, and there you go. All right. You may proceed, Ms. White.
Good morning, Your Honors. Wendy White on behalf of the appellant, Elroy Gutierrez. And please forgive me, I have a bit of a cold, so if I'm either talking louder or less loud than it seems like, it's probably because my head's all stuffed up, so I apologize for that. Your Honors, I would like to really focus on three of the arguments, and I think two are more self-explanatory. The first argument is the argument regarding the motion to suppress. The issue that we've raised, of course, is that the suppression, the denial of the suppression was an abuse of discretion, and the motion to suppress, particularly with respect to the aspect of the motion that addressed the initial stop as being without reasonable suspicion. And of course, we do look at, and this court will look at, the totality of the circumstances surrounding that initial stop, and will not single out any individual factor as saying that one is not sufficient, this one is sufficient, whatever, however we want to look at that. We have to look at the totality of the circumstances. But as I was preparing for the argument today, it occurred to me that in looking at, and I'm going to pronounce the officer's name as Officer Weekman. I'm not sure if that's the correct pronunciation, but that's how I will refer to the officer, DPS Officer Weekman. So it occurred to me as I'm reviewing this, as when Officer Weekman testified at the trial, he testified about two kind of separate clusters of information that he used in making his decision to stop. One of those clusters of information that he used were the initial observations that he made when the vehicle passed him on I-17. And I'm sure the court has read through his observations, but basically what he said was that the first thing he noticed was that the car, he noticed that it slowed down from 75 miles an hour to 70 miles an hour, apparently when it saw him. He noticed that the driver appeared rigid, wouldn't look at him, and had his hand positions on the wheel at 10 and 2, and that both windows were down even though it was 100 degrees out. Those were the first things that he noticed, and what he said about that later in the cross-examination was that the reason that he pulled out after seeing these factors, the reason that he pulled out to follow Mr. Gutierrez was because those were to him, and I quote from the evidentiary hearing on February 25th, 2015, quoting at page 64, that the reason he followed the Mr. Gutierrez was that those were to him indicators that he looks for possible interdiction. So initially, his observation of Mr. Gutierrez and of the vehicle were that he was looking for potential drug indicators in this stop. After he pulled out and followed the vehicle, he then sees two other things which make him suspicious, but not for drug involvement. Instead, the other things that he sees that are suspicious for either an impaired or actually either a tired or impaired driver, as he stated. And those factors were simply that he saw the vehicle brake twice as he was following it, and even though it was going less than 75 miles an hour, and he saw the vehicle right side tires cross the white line on two separate occasions. His reason for stopping the vehicle, as he testified, was he stopped him for, quote unquote, the weaving, which again is at page 58 of the same evidentiary hearing. So when we're looking at the totality of the circumstances, do we look at the totality of the circumstances in these two separate clusters? Were the first factors that he noticed, which he noticed as being factors for, quote unquote, possible drug interdiction, are those factors now then transformed into factors that provide, in the totality of the circumstances, sufficient reasonable belief that criminal activity is afoot, and particularly whether or not those factors had anything to do with driving while impaired?
Is your argument that the first set of factors should not be considered because those factors just made him watch the car carefully?
I think they're all part of the totality of the circumstances, but I think what it does is it really shows that this was in fact a profile stop, and was in fact. And so those factors can be taken into consideration in determining credibility of the entire kind of totality of the circumstances. But it is, and I'm not sure the answer to whether or not they should be just disregarded or whether we just look at them again in the totality of the circumstances. What I found, what was interesting to me in his presentation is that he's actually he himself was looking at this from two different perspectives. The first perspective was, I was looking at these factors because they are the kinds of factors that I've been told have to do with the possibility of carrying drugs, but in the ultimate decision to pull Mr. Gutierrez over, he reasoned that it was because that he put on the brakes two times and crossed the white line twice. So
it stopped him for you couldn't. It would not have been legal for the officer to pull over the defendant based on the fact that he was looking straight ahead and was driving under the speed limit.
Exactly.
But don't we have cases that say that's not a problem if factors like that cause an officer to observe a driver more carefully, and then the officer notices an infraction?
Oh, yeah, absolutely. I mean, I don't think I wouldn't postulate that an officer can't drive down the road and see something like it's a red car and say, "Ooh, I'm going to look at that car a little bit more stringently because I happen to know that red cars, drivers."
That's what you hear.
Yeah, to drive faster. So no. But then the question becomes: so certainly his observation can be based on anything. It doesn't even have to be based on reasonable suspicion. He could look at any driver and whatever, he might look at it more carefully. And if he then sees factors after that rise to the level of reasonable suspicion or a traffic violation, the officer would certainly have the right to pull over that vehicle. But in this case, what I'm trying to point out here is that the observations he made after the vehicle passed him are simply that he saw the vehicle brake twice, and he saw the vehicle, the right side tires cross over the white line on 2 occasions. So those are the factors that actually led him to the stop. Now, if the initial factors, and we'll go back to those, because it's kind of a damned if you do, damned if you don't kind of criteria here with the initial factors. One being that the driver, that Mr. Gutierrez was holding on to the wheel in an appropriate fashion that we all are taught to hold on to the wheel in that manner. The windows are down on a hot day. And the damned if you do, damned if you don't kind of consideration here is that that he observed that Mr. Gutierrez didn't look at him. Well, interestingly, I'm sure the court recalls in the other Gutierrez, the Gonzalez Gutierrez case, the officer in that case, in Gonzalez Gutierrez, which was cited in my brief, in that case, the officer testified that one of the things that made him suspicious of the driver was that the driver did look at him. Yeah. So, it's kind of if you look at him, you're suspicious. If you don't look at him, you're suspicious. So all we have here so even if we look at all of these factors and say, do all of these factors together raise reasonable suspicion to believe that Mr. Gutierrez was involved in criminal activity, I suggest that they do not.
I'd like to ask you to address the motion to sever. Make sure you talk about
the motion to sever. All right. So in any event, those were the factors that I feel are the most important here, is that the totality simply doesn't rise to the level of reasonable suspicion. So with regard to the severance argument, the one issue I'm raising on the severance argument is that the defendants had mutually antagonistic defenses. And the state in its response brief indicated or suggested that they are not mutually or inherently antagonistic because you could believe one without believing the other. And
it could have been both of them.
And yes, and so basically, if you look at the defenses, Mr. Gutierrez's defense was that he did not knowingly transport methamphetamine for sale. Kenneth Montiel, his co-defendant, was the one that put the drugs in the car. He didn't know anything about it, and when he said that everything in the car was his, all he really was talking about was the heroin kit that he had on his personal possession.
How was the trial any different? How did the trial proceed any differently than it would have had it been severed?
Well, if you look at the actual result, the result was that Mr. Gutierrez was not, in fact, convicted of the one offense of the offense for transporting heroin for sale. That was in the back of in the trunk area of the car. He was convicted only of personal possession of heroin. So I believe that there's at least some, his credibility and the story of Mr. Montiel was not completely agreed to by the jury, because they did in fact agree with Mr. Gutierrez that he didn't know about the significant amounts of heroin in the back of the car.
But was he unable to offer evidence that he would have offered otherwise, or what? I mean, in terms of the evidence coming in, how was that any different due to the failure to grant the motion to sever?
Well, if it had been severed, there would have been a different situation in whether he testified or not. He did testify in his own defense, and if it had been severed, then he would have had the choice. He would have made that choice under different circumstances, and may have made the choice not to testify. As to any evidence, would it have been different? Honestly, I'm not really sure that there would have been different evidence that would have been raised or would have been included or that would have been excluded had the severance been granted. Really, it's more a question of whether or not he would have been arguing against Mr. Montiel's position that he was the one that had the drugs in the car. So it's really more of a factor of how the jury would have perceived his testimony or his credibility if he was not also fighting against Mr. Montiel's position that he was the bad guy.
So so if I understand it, you're saying the only difference is that the jury wouldn't have heard Montiel's argument. That's not me, it's him.
Possibly would not have heard. He wouldn't have heard that argument.
They wouldn't have heard that argument.
That's argument.
Wouldn't have.
That was the only.
That's really the only thing. Yeah. Yep. So, I did want to argue or discuss the last two.
Wait a minute. Before we move off the motion to sever, so if I understand you correctly, you're saying that that your client would not have testified if the motion had been granted?
I'm not sure whether he would have testified or not, because that wasn't the circumstance. But when a client makes a decision to testify or not testify, it's based upon the totality of the circumstances, the totality of the trial as it exists and what they're expecting is going to be presented. In this case, he made a choice based upon the fact that there was not a severance. Whether he would have chosen or not, I don't know. I didn't get to make that trial decision with him, and I don't know if he would have or not, honestly.
It just seems to me that he benefited from being able to testify because he was acquitted of some of the charges.
And he might have made that decision again. I really can't honestly say that he wouldn't. He made that decision based upon the circumstances as they existed.
Okay.
Is there anything in these missing exhibits that we should be looking at directly bearing on that?
To be honest, I'm not sure if there's anything specific. I wish I could direct you to something specifically, but I can't. So, I do want to briefly, very briefly, discuss because I think it's actually a very simple argument, but the final argument on the flat time versus mandatory flat time versus discretionary flat time.
Why isn't this Hansen?
Pardon?
Why isn't this a Hansen situation?
This is not a Hassan situation because in Hassan, this issue was not raised directly. In Hassan, the issue was only whether or not, under the circumstances of that case, in the circumstances of that case where that Mr. Hassan accepted a plea in which he agreed to a flat time sentence, and therefore and his argument at that time was that even though he had agreed to a flat time sentence, that he was entitled to and had a right to right to early earned release credits. I'm not arguing that. nobody has the right under 133407 to earned release credits. All I'm arguing is that 133407E, which mandates if a person is sentenced under that subject, mandates or allows for the mandatory imposition of a flat time sentence, that is not the same as 133407F, which gives the court, in my reading of it, gives the court the discretion to impose earned release credits, or to allow a defendant to earn release credits. So it's not an entitlement issue as it was in Hassan. That was how it was raised in Hassan. What it is that the court has the opportunity to do one of two things: either sentence to flat time or sentence to earned release credits.
Thank you.
And the only other argument that I wanted to address was the issue of the judicial kind of interference, I guess you will, or judicial vindictiveness in the plea negotiations. The state, in its response, had indicated that the court had not interjected improperly in the plea negotiations, and I simply wanted. There were two things that the state said in the response brief. One was that the court did not interject, and in fact, the court stated that the court was would give the defendant the shorter period of time, a period of time that was shorter than what the offer was, and specifically stated it was a shorter. The other aspect the state said in its response brief was that there were new factors to consider that hadn't been apparent during the plea, and one of those was Mr. Gutierrez's prior convictions. Right up front on page 3 and 4 of the hearing, the state noted those prior convictions, so they didn't come forward. And I will reserve my 1.3 minutes if possible.
Thank you.
Thank you. Or 1 minute and 30 seconds.
Good morning, Your Honors. Lindley Wilson, Assistant Attorney General, on behalf of the State of Arizona appellee in this matter. If it's okay with the court, I'd like to start with a motion for severance, because I think the court seems interested in that particular issue. And just in reviewing the defendant's motion to sever, I just wanted to note for the record that as of the time that the motion was made, the appellant stated that Mr. Gutierrez will not likely testify that he made any confession as to actual knowledge as to what was found in the vehicle. Mr. Gutierrez should not face the possibility of impeachment by both the state and his co-defendant. So that was essentially the claim, or the reason that severance was argued initially. And further, the court did actually make specific findings on the motion for severance, and that's record item 59. The trial court specifically found that the evidence wasn't facially incriminating to either defendant. There was no harmful rub-off effect. There was not a significant disparity in the amount of evidence introduced against each co-defendant, and specifically to appellant's argument, the defenses were not mutually exclusive, so that the jury would have to disbelieve the core of the evidence of one defendant in order to believe the core of evidence of the other defendant. And this case basically boiled down to each defendant denying knowledge of the methamphetamine in the car.
How is that not mutually exclusive?
Under Cruz, it's
both pointing the finger and saying, I didn't know, he knew.
And that is part of their defense, but for purposes of severance, those are not so mutually exclusive as to require severance. Joint trials are the preference, and under State versus Cruz, which I believe is cited in the materials, there the Arizona Supreme Court held that non-involvement, or a claim of non-involvement and basically no knowledge of drugs, which is what this case is, does not require severance. And to Judge Johnson's point, the compelling prejudice that really requires separate trials is usually in the form of something like other act evidence, or evidence that would not ordinarily come in. In Cruz, it was actually, I believe, one of the co-defendant defended on the grounds that he there was some part of his defense indicating that he was afraid of the defendant. And so the state's key witness testified about all of these other things that the defendant was alleged to have done previously, such as being involved in organized crime and threatening to break someone's legs on several occasions. So there was all of this other act evidence that came in that would not have ordinarily come in if he had a separate trial. And that's really the compelling prejudice part of the severance question.
What is a mutually exclusive? I mean, that's a standard. What is
Right.
it?
I think it would be a better case here, maybe if Montiel, the co-defendant, had testified that this whole thing was, appellant's plan, or that if there was some more incriminating evidence admitted against appellant, to say, yeah, he absolutely, just going on in details about, he absolutely knew that these drugs were in the car, or something that is more than what this case is, where the jury necessarily has to disbelieve the defendant in order to.
So the jury could have disbelieved both of them and simply said they were both involved.
They certainly could have. They could have concluded that someone else put the drugs in the car. And I want to address the recordings for just a brief moment, because I do think that those are important to show what this evidence was that incriminated the defendant. He made some incriminating statements at the scene, and he, there's about a 4-minute recording when they're both in the back of the patrol car, is basically conspiring about what their story should be to the officer. And he says, I'll take the rap for the drugs, and there's some discussion. He's trying to encourage Montiel to take the hit for the guns because he's a prohibited possessor. And so in a separate or joint trial, he would have had to explain those statements to the jury, or chose not to testify and just let the state introduce that evidence. So as a preliminary matter, there was no severance was not required in the first instance, because the evidence was so intertwined that it's not that there was separate evidence introduced against each defendant.
What's the significance of the failure to renew the motion at the close of evidence?
I would like to address that, because there's an error in the state's answering brief that we sincerely apologize about. But in the standard of review section for this issue, I think we indicated that it's for an abuse of discretion. And upon further review of this record, the defendant actually renewed the severance motion immediately after voir dire and preliminary instructions, but before anything substantive had occurred. So he never gave the trial court an opportunity to determine whether there was actually prejudice in this case. And so under, in retrospect, this court should actually review this. If it's reviewed at all, it should be under fundamental error review. And actually, Division 2 has applied waiver in a similar context and just declined to review the issue at all, because it amounts to using this issue as a whole card for review and saying, for the first time on appeal, I was really prejudiced by this lack of severance.
Would you remind us of that Division 2 case, please?
Absolutely. It's State versus Flythe. And the citation is 219 Arizona 117, and that's Court of Appeals 2008. And granted, the state had argued that waiver applied in that situation, so I understand we didn't fully make that argument in the brief here. But even under Flythe, there the co-defendant actually renewed the motion at trial. And the defendant was trying to argue, well, my co-defendant renewed it, so that was sufficient to allow the court to determine whether any prejudice occurred. And Division 2 disagreed, saying that's not enough under the rule that says severance has to be renewed during trial at or before the close of evidence. So that is arguably it's a little unclear, but the comment to the rule states that renewal must occur at or after the time at which the suggested prejudice actually occurs. And so that allows the court to reconsider its prior ruling and really flesh this out on the record. So to the extent this is reviewable at all, it should be under fundamental prejudicial error. And I just wanted to note also that the jury was properly instructed to consider the charges separately against each defendant. They were also instructed on mere presence, accomplice liability, to consider the charges against each defendant separately. And they did acquit this defendant, appellant, of one count of the aggravated DUI and convicted him of a lesser included on the narcotics transportation charge. So that is evidence that, for all we know, trial was proceeding favorably, and he made a strategic choice not to renew his severance motion because things were going pretty well. And so one last point on severance is that to the extent there's any suggestion that had there been a separate trial, he may have chose not to testify, that's just sheer speculation and certainly not enough to show compelling prejudice in this case. And so ultimately, the state would request that the court either find waiver under these circumstances or perhaps provide guidance about when a claim will be precluded under this rule and when the renewal has to be made at trial for purposes of Rule 13.4c. And at best, fundamental error should really be the standard of review. On the motion to suppress, appellee agrees that that Officer Weekman had two distinct bases for the stop. In other words, reasonable suspicion was sufficient under either ground, either the sleepy or impaired, based on him crossing the white fog line on 2 occasions, or because he actually had specific reasonable suspicion of drug activity based on all of these circumstances.
What was the reasonable suspicion of drug? The judge didn't reach that, right?
The judge
found
did
that it
not.
was under caretaking or traffic violation.
Correct. I believe the judge's ruling focused on just the traffic stop violation. But ultimately, the standard of review is de novo of the entire suppression ruling, and the state did argue below that there was sufficient evidence of criminal activity. So,
Sufficient evidence of criminal activity because he didn't turn and wave to the cop as he went by.
no, the state believes there are a multitude of.
No,
there's a lot of other circumstances
okay,
here.
The windows being down.
Mm-hmm.
He doesn't look at the cop as he goes by him. He's sitting rigid and slows down, which probably everybody in this courtroom has slowed down as they've passed a cop.
Mm-hmm.
And then the traffic violations. That's enough for drug activity?
It absolutely is, deferring to the officer's specialized training and experience in detecting drug activity. And there actually was testimony to this point at the suppression hearing of considering these factors in isolation. Sure, it could have been an innocent motorist, but
what, I mean, there still has to be an objective criteria. It can't be, I'm suspicious.
right.
Deferring to the police officer, as we went into their training. It's not enough to say, gee, I looked at all these factors and I thought he was carrying drugs. I mean, isn't there a big jump there about for a stop to think that there's an objective basis? You can point to objective factors to say that crime is afoot.
I think that is enough under the case law and under the specific facts presented at the suppression hearing. And in addition to all those factors you listed, we also had a vehicle with New Mexico license plates on a highway connecting a major source city for drugs to. Those are all certainly factors under United States versus the years.
The Ninth Circuit has held that the entire western portion of the United States is a drug corridor. So, I mean, and we're not bound by the Ninth Circuit's determination, but I understand that.
Right.
But it does strike me as being a jump from, gee, I was really concerned about this guy's safety and whether the guy was impaired and there was drug activity. What happened once he stopped him?
Mm-hmm.
Let me clarify it this way. Once he stopped him and he saw that he wasn't impaired, was there another factor at that point that he pointed to that seemed to indicate that there may have been criminal activity afoot?
There were a lot of circumstances discussed after the fact, and of course those aren't really on appeal, because they did challenge the length of the detention and the subsequent events below. So there were other facts that were developed to indicate drug activity.
They called a dog out, right?
Right. There was a canine.
Right.
Mm-hmm.
Before they did that,
Right.
I mean, sometimes these cases come up and they say, well, I was stopping him for something else, and then once I stopped him, without asking him anything, something else popped up at me that bothered me. Was there any evidence of that?
I believe he made contact with with both both occupants, and Montiel, his hands were shaking as he handed him some things, and they had inconsistent stories about where they had been, but I haven't reviewed the record specifically to, address when each of these observations occurred after the initial traffic stop. But I do want to just sort of mention that at page 64 of the suppression hearing, Officer Weekman testifies that The reason I followed it is because it appeared to me that it slowed down and not needing to slow down because, again, it was going the speed limit. And then the driver's hand positions is rigid, not looking at me, the windows being down at almost 100 degrees. Those were, to me, indicators that I look for possible interdiction.
What's your best case that those factors by themselves are sufficient?
United States versus Arvizu is the Supreme Court case really that talks about drug profiling evidence being and really deferring to an officer's specialized training and experience on these types of things. So that's 534 U.S. 266, and it also rejects the divide and conquer approach. We've also cited State versus Evans that was recently decided by the Arizona Supreme Court that officers don't have to rule out innocent explanations for criminal activity when looking at whether reasonable suspicion exists.
Sure.
And one final note about Gonzalez Gutierrez, that's the case where there was there was a Hispanic driver glancing, scratching his head, gripping his steering wheel tightly, and that was insufficiently particularized to provide reasonable suspicion, but the reasonable suspicion there was of illegal alienage. So that simply wasn't enough to establish that the person may be here illegally. This is not that case. This is suspicions of actual drug activity. And Officer Weekman has 10 years of experience with DPS and testified extensively about his experience and the training and the courses that enable him to detect drug activity versus an innocent motorist. So I believe the record is sufficient to support either ground, and even if the court's just inclined to look at just the traffic stop or the traffic violation for weaving twice over two
Let's say it's
white
enough
lines,
for the stop.
I believe that
to do
that's for enough.
Traffic violation. The detention, once the traffic violation is determined, you can't continue. I thought the U.S. Supreme Court had held you cannot continue the detention longer than necessary to resolve the traffic violation.
Well, certainly that issue is not briefed here, and if it were, I believe that the circumstances would show there was a reasonable basis to detain them in the patrol car and conduct the search. So
Right, that's why I was asking you. I mean,
right.
now we've come full circle, but that's why I was asking you: was there anything else after he stops him, sees he's not impaired, that the officer suddenly says, well, wait a second, there are these other factors, and now when you add that to everything else,
Right.
I am suspicious about the drugs.
That certainly, there was, frankly, a lot of other evidence that came in after he conducted the stop. The appellant gave a fake name, I believe, twice. He looked up his MVD records, and he was actually, his license was suspended or revoked out of New Mexico. So, as to the detention, certainly that was reasonable.
Okay, so that would have been enough right then, because he hadn't, at that point, he hadn't concluded the investigation as to whether he was impaired or whether there was a traffic violation, but he simply said, I'm going
Right.
to check your MDT and what's your name. He gets those and suddenly saying, what's going on here?
Right.
Okay.
I see what you're saying, yes.
Okay.
I'd like to ask you about a totally different topic.
Sure.
And, do you happen to know whether it is a common practice in Yavapai County to have the trial court judge assigned to try the case run the settlement conference?
I do not know that on top of my head. I'd be happy to research that. And,
Oh, thank you. That's fine.
So I do not know. But we would rest on the arguments made in the brief regarding the judicial vindictiveness claim. We don't believe anything inappropriate happened, and there's no presumption of vindictiveness that should be applied, nor was there actual vindictiveness in this case.
What was new at sentencing that the court was unaware of at the time that she guaranteed the defendant a lower sentence than what the prosecution was offering?
Particularly the quantity of the drugs, I think, was a huge factor that was not squarely, the trial court did not know precisely about that fact when it was advising the defendant of what it was likely to impose had he accepted the state's plea offer. So the quantity of drugs, also his prior convictions, although I realize that on count one he was sentenced pursuant to the methamphetamine statute, and so, but the prior convictions still come into as an aggravating circumstance, and so those still informed the court of the permissible or what the sentence should be. Because earlier, I believe under the plea agreement, he was going to plead as if he was a first-time offender, and he had 2, if not 3, prior felony convictions, I believe.
So the judge, she, right?
I believe so, yeah.
Yeah, she was aware that there were alleged prior convictions. and probably aware there was an allegation about the size, the amount of drugs, but none of that had been proven, right?
Right. I think the state was even agreeing to drop the allegation of prior convictions if he were to enter into the plea agreement, which is, again, just for two specific, two charges, I believe he would have pled to. So quite a significant result from ultimately being convicted of 7 offenses after trial.
Okay, thank you.
Sure. The state would also submit that Hassan established the issue about flat time, and calendar years is interpreted in numerous contexts as flat time, and that's specifically what this methamphetamine statute sets forth is specific ranges in calendar years. So although the statute might be perplexing, as this court noted in Hassan was correctly decided, and there's no good reason to overrule that. So if the court has no further questions, the state would submit on its answering brief and request this court to affirm appellant's convictions. Thank you.
I can do this in 1 minute and 30 seconds. I don't believe that either State v. Leaf or U.S. v. Arvizio were cited in the state's brief. I looked at it. I did not see that. I would ask the court not to consider those cases unless the court gives me some opportunity to respond. However, with regard to the the suppression issue, I wanted to point out that I don't believe that the two driving or crossing over the white line on 2 occasions is a traffic violation. And I think State v. Livingston, the case of State v. Livingston at 206 Arizona 145, is pretty clear that that's in itself not a traffic violation, and would ask the court not to find that is a traffic violation in this case.
But it was the totality. I mean, he's stepping.
No, yes, it is.
He's stepping. There's a number of factors. As far as the traffic, let's just disregard for now the fact of driving by without looking. He's stepping on his brakes when he's not needed, and he crosses over the line twice. Isn't that enough to at least pull the guy over to make sure he's not impaired?
I would submit it's not. Driving down here from Flagstaff, saw cars driving over the white line, but the point I'm making is that if it's a traffic violation, that would in and of itself justify a traffic stop. If it's not a traffic violation, it would.
He's concerned that he's impaired because he's done that and he's stepping on his brakes inappropriately. That's enough for that, isn't it?
No, I do not agree. I would submit it's not. Thank you.
I'd like to ask you the same question I asked your colleague. Do you happen to know whether it is the common practice in Yavapai to have the trial court judge run the settlement conference?
With this particular judge, I have seen that on a number of cases.
Thank you.
Thank you.
Thanks to both lawyers for your argument and for your briefing. We'll take the matter under advisement and issue a decision in due course. Now we stand adjourned.